Thank you, sir. Uh, Respected Dr. LSS Reddy, Vice Chancellor, sir. Dr. K. Narayana, Dean Research, sir. Dr. Subharao, Principal of COE, sir. All the HOD of respective department, and my dear all participants. It's my honor to really share my view on the intellectual property right and its importance in academic institution as well as in the building a startup or some new business or MSME sector. Now today we are going to discuss about the intellectual property rights in basically three heads. First of all, we are going to see what is an intellectual property rights and what is its importance with respect to an academic institution, and second, the filing procedure with respect to the Indian patent system is concerned, and third one is the most important thing what we people generally do in drafting a patent. Basically, we'll discuss how to write a patent because see, it's a really a techno legal document. If somebody is in, suppose you are filing a patent and you have been granted after 2 to 3 years, and down the line if somebody is infringing your right, somebody is taking away your patent, holding your product, then whenever you go for an appeal to any high court or supreme court, then the supreme court is totally based on your document. Whatever you have write in your patent document, based on that document they will prosecute the thing, and they will again enforce all those right whatever has been infringed by some other people. So this drafting procedure is most important, though it's a very lengthy one. We'll try to cover it up in this scenario, and hopefully, as I talk with Dr. Sarath sir, in near future you will get another session, and bit by bit I will tell you how from a research lab to land, how your prototype from a product to that to a market will rewrite in a different way so that it get patented in our Indian patent system as well as in some other patent system in the world, and how it's get marketed. See, if you want to plant a tree by putting the water, by putting the manure throughout the year, if the tree is not yielding you any product, then what's the use of that tree? Same goes like in the patent. If you are getting a patent and you are not marketing it properly and you are not getting the money or whatever the royalty or whatever the promotion by showing your patent right through your intellectual rights, it's not a fruit issue. So all those things we are going to discuss in this 1.5 hour, whatever the situation may be. We'll try to find it out. And the thing is that now I am doing my first what we call scenario about the Indian patent system with respect to an academic institution. How it's related to an academic institution. Now come to the first one, intellectual property rights and its importance. Then we know what is right. Right is a what is a property? Property means it's a bundle of rights. Bundle of rights which is given to every citizen of this particular sovereignty or a particular country, which is protected through some statute or some act. So what is intellectual property? Intellectual property means the property related to your own creative mind. See, we have two type of property. One is tangible one, another one is intangible one. Whatever you see a car or whatever you see, whatever a property or some home or some what you call some other things which can be touched. These are come under the tangible property, and intellectual property. These are comes under the intangible one. You can't see, can't touch. You only what you call perceive the things, and you just develop that idea into a product or a process. So these are called some of the intellectual property. So basically, yes, basically intellectual property, it's again divided into two types. One is the industrial property and another is the artistic work. Artistic work or any music or any book writing, whatever you are writing there, it's get protected through a copyrights. So different act, different statute are there which is protected. These are artistic work. There is a copyright act. We'll discuss in the next slide. And the industrial property again divided into patent, design, and trademark. See, suppose I'm telling you, suppose I am using a mobile. See, suppose I am using this mobile, and this is the what do you call, this is the shape of my mobile. My this shape is let's say rectangular one. So this particular say which come under the design, this is my design layout. So I will be protected this design part through my design act. Similarly, if some new technology is there in this mobile phone which is not there in someone else, then that particular technology will be protected through Indian Patent Act 1970. Similarly, suppose I am putting my logo or I am putting a small mark there. Let's say suppose this is a MI phone, this is a specific MI. These kind of mark, these are protected through the trademark. So these are the different statute, different act, different what we call the different intellectual property act which protect these kind of intellectual property. Now other intellectual property we'll also discuss one by one, that is the geographical indication, the layout design of integrated circuit, the trade secret. These are also in some kind of intellectual property which are generally protected through our Indian patent system. Now come to the different area of the IPR, intellectual property right. As I already told you, the patent. See, what do you mean patent? Patent means what always relate to a technology. Whatever you are devising through a technology or a, what you call a technical background or whatever you are inventing, this come under the patent. So in day-to-day life, in the day-to-day engineering life, what we people are doing by making the life of the people get easier, we are getting some technology into their life so that their life getting easier and so they are enjoying their life. So these kind of product, this kind of process can be get me what you call protected through this intellectual property right, that is called the patent. And generally it is governed through Indian Patent Act 1970 for invention. This is actually what is patent, because we are giving an exclusive monopoly right granted to inventor or his assignee for his invention with some limitation. See, it's an exclusive monopoly right. Why I am saying it's an exclusive monopoly right? I mean it will exclude others from using your product or your process, or by selling or by importing or by what is called using. So actually these will exclude the other, so your right will be only totally excluded other, so that only you can use. It's a monopoly rights. And see, patent it's only a territorial right. See, the different country has a different patent system. See, since it is a territorial right, the Indian patent right only applicable within the jurisdiction, within the territory of the India. Similarly, if you go to that particular product and go and you will say this is my product, I patented in India, and you are going through the US and you are saying I'm having the right of that particular product, then it will not valid. See, the US patent, that is a different right, that is a different territorial right. So you first of all what you will do, you go there, you have your product, you just get listed there, get patented certificate from the respective country, then you can say yes, my product is get patented both India as well as in US. So in different country you have to go and what do you call, you have to protect your right. See, this is a different kind of jurisdiction, different jurisdiction, you have to again protected this right in different jurisdiction. Now come to industrial design. As I already told you, this is a design cover under any pattern or any ornamentation or configuration or a different feature which are appealing to eye. This protected on the industrial design. Similarly, trademark, any logo, any label, any name, any combination for any product or for any service, that's come under the trademark. If you want to get your trademark ready, then you have to come to Indian Trademark Act. These are we also discuss in the following what you call the slides one by one. Now come to copyright. Copyright, suppose you are writing a book and if you want to protect it, so you first of all you have to take the copyright of that particular book so that nobody can infringe your right. Similarly, geographical indication. See, this is the most important one, because we are a part of we are such a country having vast number of different culture, tradition, different area, different geographical location, and they have their specific value. So actually what we did in the geographical indication, we particularly give a particular protection to a particular what you call geographical location, so that that particular geographical location can stay, and they can the indigenous people, they can enjoy their right with that particular indication. If we take the example of geographical indication, if we discuss what about the Tirupati Laddu? See, The Tirupati Laddu, it was the GI, it was given to the geographical indication, it was protected through the intellectual property right, and the right has given to Tirupati Tirumala Devasthanam, because that particular type of Laddu that is basically having is different quality and different size and different flavor, so that nobody can make such kind of laddu in any part of India or any part of world and sell to the market this by just printing a logo that is the Tirupati laddu on the name of Tirupati laddu. So then, to protect that kind of infringement, what we did, we gave a specific geographical indication status to the Tirupati, so that they can sell their product under that particular brand name. Similarly, if we again discuss another one example, the Venkatagiri sari, it's a Venkatagiri sari. Most speciality about that sari is a purely cotton sari. It is having a gold and some silver jari work in between the cotton sari. So that particular design is a particular specialty of a Venkatgiri, and Nellore is a particular location in Nellore district. So that particular geographical location is what you call perceive only that kind of sari. So no part of India, no part around the world can make such kind of sari. That's why I give a particular geographical location that particular Venkatgiri sari. So these are all the intellectual property whatever we have discussed now. So uh, the next one will discuss about what are the act, what are the different statute that cover this intellectual property. As I already told you, the Intellectual Property Act 1970 that basically designed to cover the patent, the Indian Patent Act 1970, which cover the patent intellectual property right. Now, the similarly, we are also protected the trademark through a Trademark Act 1999. Similarly, we are protecting the copyrights, protecting the copyright intellectual property through the Copyright Act 1957. Similarly, the geographical indication of goods also come into existence in 1999. We are also formulated an act and enacted the Design Act 2000. Similarly, Semiconductor Integrated Circuit and Layout Design Act 2000. See, this particular Semiconductor Integrated Circuit Layout Design Act, particularly it was a brainchild of Ministry of Electronics and Communication. See, as we know, after 1999, when our economy get widely open, we become more developed into a service sector, and that basically that contribute toward our our electronics and computer integrated system. So what the Ministry of Electronics asked us better to formulate an act so that we can protect our own particular product about the related to electronics or any computer related circuit. On behalf of that, we formulate an act and we enacted that in 2000. So basically, these cover under the Semiconductor Integrated Circuit Layout Design Act. So these are the different statute related of the intellectual property right through which we just stop the infringement of our intellectual property rights. Now come to what is patentable. See, what is patentable? Patentable, actually, whatever you are designing, whatever you are thinking, let's say I'm thinking about a pencil. So this is my pencil. I just think about that. So this is my pencil, and the pencil having a razor on the top of it, there is a razor, so that it can be used as a multi-purpose. I can write it in on a paper, then I can erase it by just throw it off it. So what we did, this is a kind of invention. Invention, what is invention? Invention means a new process or a product. New process, keep in mind it's a new process or a product. See, if it is not a new process, then it is not patentable. So any invention which is totally new, and it must involving inventive step, and it is capable of industrial application. Capable of industrial application means it must be produced in an industry level so that it can be marketed and commercialized. Now come to patentable product. Patentable product means, suppose this is my invention, this is totally new, and this is having an inventive step. Inventive step means, suppose initially somebody else having a pencil that having only the simple pencil, they don't have any eraser. Now I come with another pencil, and I am top of it I just put an eraser, and I said See, initially whatever the pencil was there without any eraser. Now I am coming with a invention. This is having a eraser. So this is technically advanced prior to the prior pencil, which is initially there without an eraser. So there is a technical advancement is there. That particular technical advancements leads to your inventive step. Once you discover your inventive step, then now the product become patentable. So to get a product or process become patentable, you must keep in mind the three words. First of all, it must be new, it must involve a inventive step, and third up, it must be industrially applicable. That means it must be capable of producing large number in the industry. Now, every jurisdiction or every country, every sovereignty has its own statute, so that they can stop the product get patented. Why we do like that? Because suppose somebody is, let me take one example. Suppose somebody is coming with an medicine, let's say riponavir. On that particular product, he is taking that product patented with Indian patent system, and he's making the 10 tablet and selling the 10 tablet around 70 to 80,000 rupees to some people throughout the territory of India. See, the 10 tablet each cost for around, let's say, 7,000 rupees or 8,000 rupees. So then the people like us, the middle, so the below poverty line of the middle class people, they can't afford such kind of product. So to stop this kind of product, what we did, we made an act so that this kind of product can stop by different section of our Indian Patent Act, which will debar that particular product to get patented. So based on that public image, public use at large, we enacted certain sections, certain rules in our Indian Patent Act. So if your patented product is what is called sellable, or if your patented product is not debarred from that particular section of the act, then it is patentable. So if a product is patentable, you have to again keep in four things in mind. First of all, it must be new, it must have it must have inventive step, it must be capable of industrial application. Third, it not barred by section 3 and section 4 of the Patent Act. We'll discuss this section one by one. Now come to what is product. Product means it might be any apparatus, it might be any device, it might be any machine, it may be any chemical product, maybe drug, food, or their composition, or any biological product. So these products comes under what we call the patented product. Now come to what is non-patentable. See, these are the non-patentable thing. These are the idea. These are the product. These are the process which are not patentable as per Indian Patent Act 1970. Whatever we have discussed in the previous slide about the different section of the Indian Patent Act, these all this section cover these kind of things. See, now come to the invention that cannot be patented are the frivolous one, but is contrary to the well established of natural law. Suppose you are inventing a product which is saying that it will keep on moving on and on without using any fuel. So it is against the natural law of property. So if you are not putting any fuel to it, if you are not getting any giving any energy to it, how it can work from on and on and on and on. So it is contrary to the well established natural law. So these kind of things are not patentable under Indian Patent Act. Similarly, if anything which is contrary to morality or injurious to public health or to the environment, see, still we are debating with the scientist people about the GMO product, the genetically modified organism. Some of the people saying it's a pros to society, some of them say it's a cons for society. Still you are debating. So whatever the product which is injurious to environment or injurious to any public health, these are not patentable. So similarly, any scientific principle or abstract theory. See, before going to that particular point, let me remind you, any idea is not non-patentable until and unless you are not developed into a product or process. Only idea per se is not patentable. You have to develop it into a product or a process. Until and unless you are not developing into a product and process, it is not patentable. So these are the similarly the new property or use of a known substance. Suppose somebody has already discovered a machine And let's say, let me take one other example. Let me say one drug. Suppose somebody is already discovered a paracetamol tablet, and he's saying the paracetamol is antipyretic one. So after 10 days, you are coming and saying, I got the new property of the paracetamol. It is used for analgesic property. See, you have somebody has already developed that particular product. What you are doing, you are just giving a new use to a particular product. So these kind of new use of a known substance is not patentable. Yes, it is patentable if you show that if there is a increased efficiency of the antipyretic of that particular product up to 90%, if you modify it or by adding some salt to it, then it is patentable. Similarly, if you go to any treatment method or including diagnostic method, these are also not patentable, but the diagnostic kits are patentable. Similarly, those people who are working on the computer program, see, computer program per se or algorithm is non-patentable, but in a recent judgment by Honorable Delhi High Court, the Delhi High Court said any computer program, if it is efficiently used for a particular appliance, or if it is efficiently used for a particular product, or it is used efficiently to improve the work of a machine, then it is patentable. The Delhi High Court just recently concluded in its judgment and saying that computer program per se is not patentable. If you are showing its application and its efficiency, then it is patentable. Similarly, any literary work, dramatic work, or artistic work, these are all not patentable because these are comes under the Copyright Act. Similarly, the presentation of information or method of playing game, these are also not patentable. So these are the things, these are the all the process of product. These are not patentable under the Indian Patent Act. Now the patentability criteria. Suppose you are having an invention. As I already told you, what is invention means any new product or a process that involving inventive step and capable of industrial application. So suppose you are having a new product which is having a technical advance as compared to the prior existing one, and it is industrially productable, then if you are passing through the three criteria, if it is a new one, it having a technical advancement as compared to the prior one, and now if it is industrially applicable, and if it is not comes within the purview of section 3 and section 4 of the Indian Patent Act, then this kind of product or this kind of process is patentable under our Indian Patent Act. So these four criteria you must keep in mind before working on a specific kind of product or process. Now come to who can file. See, suppose you people are working on the lab, either you are working alone or either you are working jointly. So suppose me and my colleague, we both are working on a particular lab under a particular university. See, me and my colleague both are working on a particular product. So me and my colleague both are the true inventor or the first inventor. So because we are inventing the thing, so we are the true and first inventor. So by any person claiming to be true and first inventor, so me and my colleague both can file the product, file a patent for the particular product. Now come to another person who is the assignee of the true or first inventor. Suppose we both the people are working under a university. So we are using the resource of a particular university. So what we'll do, we'll assign our that patented product to our particular university, so that instead of us, our university will file that particular product on behalf of the applicant, on behalf of the university name. So he become the assignee. Me and my colleague become the true and first inventor, and my university will be the assignee who will be assigned by us as the applicant of the particular product. Now third person, if any legal representative of a deceased person, he can also file a patent. Suppose before my death, if I write down in somewhere else that if after my death the sole right will move to that particular person, then he become my legal representative. That particular legal representative become eligible, can file the patent in the Indian patent system. Now come to category of application. See, we have basically divided into four category of application. First is the natural person, second the startup, third is the small entity, and the large entity. Sorry, some mistake is here. This is a large entity. Who is a natural person? As I already told you, whoever were working in the particular field or particular lab, we are the natural person, because from us, from our intellectual mind, the idea came into existence. So we become the natural person. Now the startup. As per our Indian Patent Act, the startup is the entity which is having a turnover of less than 25 crore per year, less than 25 crore turnover per year, and his registration does not exist more than 5 years, then he can comes under the startup. Now we have the Startup India program. If any authority of the Indian government, if he can assign your what is called establishment as a startup, then you are also eligible for that particular startup category. Now small entity, according to the MSME Act 2006 and its amended version 2007, any entity who is following through this particular act, they can come under that particular group. And beside all those three entity, those people who comes on not comes under these three entity, they can fall in the large entity. Why we have divided these particular applicant? Because for those applicants, the amount of fee payable to Indian Patent Office is different. See, natural person, though he is an either a student or a faculty member, he is very independent one. He can go and file a patent if he is not put any agreement with the university. That for a natural person, the fee is very nominal. Similarly, for a startup, the fee is also very nominal, but little bit higher as compared to natural person. Similarly, the small entity, the fee is little bit higher as compared to both natural person and startup. In large entity, we will discuss also this fee is quite larger one as compared to natural person, startup, or the small entity. So these are kind of applicant who can also file in our Indian patent system. Now come to jurisdiction for filing. See, if you people are working in different part of India, suppose if you are working in the Andhra Pradesh, you can't file in Mumbai. So you have to choose your particular jurisdiction. Your jurisdiction is the Chennai. So based on this kind of specific jurisdiction, we divided our whole Indian patent jurisdiction into four parts: the Mumbai office, the Chennai office, the New Delhi, and the Kolkata. So those people or those work which has been invented in Maharashtra, Gujarat, Madhya Pradesh, or some other Dadar Nagar Haveli, these are come under the Mumbai jurisdiction. Similarly, if somebody work in the Kerala, Tamil Nadu, Karnataka, Pondicherry, Andhra Pradesh, they are comes under the jurisdiction of the Chennai part. Similarly, if somebody is working in the New Delhi, in Himachal Pradesh, Rajasthan, Jammu Kashmir, Punjab, these people have to come within the jurisdiction of the New Delhi. Similarly, if some people are working in the rest of the India, suppose let in Kolkata, in Odisha, in Jharkhand, or in Bihar, then those people they have their jurisdiction in Kolkata. So if you are working in the Andhra Pradesh, then you have to file in Chennai Patent Office because your jurisdiction is specified. So based on this certain kind of jurisdiction, we have divided our patent office into four major categories based on the different location of the Indian territory. So now come to the different offices which has been located throughout the India. We have the patent office. It is generally, as I already told you, it's already there in Kolkata, New Delhi, Chennai, and Mumbai in four different major metro. Now trademark registry. Beside these four metro, we are having a new office that is located in Ahmedabad. Similarly, design wing. If you want to if you want to protect your intellectual property, that is, if you want to protect and design, then you have to file in Kolkata Patent Office. Similarly, if you want to file a geographical indication, if you want to protect your geographical indication, you have to go through Chennai office. In copyright, you have to go through New Delhi. Similarly, in semiconductor and IC Layout Design Act, you have to go through the New Delhi Patent Office. See, up to patent, we have divided the jurisdiction into four different metro city. But if you are having a design wing, if you want to protect your design, or if you want to protect your geographical indication or copyright or semiconductor, then you have to move the different patent office which are located in your respective places, irrespective of your jurisdiction area. The jurisdiction is only applicable to your trademark and your patent only. So beside this, what our Indian government said, we are also having an what is called training institute. This is Rajiv Gandhi Intellectual Property and Management Institute. This is situated in Nagpur. For those faculties, for those people, those scholars who want to make a career of this through this Indian patent system, they can approach this kind of they can approach this institute. They can enroll there for 3 month or 6 month course with very minimal amount. They can train there. They can write patent. They can form patent for different people. They can file. They can go. They can appear for Indian patent agent. So they have different what you call different kind of career with different patent scenario. So after all this, we are having appellate board. See, why we need an appellate board? Suppose somebody is taking away or infringe your right. Where you have to go? You must have a particular place so that you can go and say, sir, my right has been infringed, so better to protect this. For that, we make an appellate board. The intellectual property appellate board is situated in Chennai. So if you think if a patent is infringed by someone else, you can directly file there through an application that my patent number this, having application number this with the invention this has been infringed by some other people, so kindly protect it. So these are all different kind of offices which are comes under the Control General of Patent and Design and Trademark Act. So now come to the filing at patent office. Until now we know what is a patent, what is an invention, who can file a patent, where we can file a patent. Now up to that we just make sure about the basic idea of the patent. Now the thing is that where to file a patent, how we'll file a patent. See, basically we can file a patent either physical mode or either through electronic mode. So prior to 2007 we are asking for people to go through physical mode, but after 2007 we are asking the people better to go through electronic mode, so that if any person or anybody who is working on a particular lab, by sitting in his lab, he can make sure about all those documents which are prerequisite for a patent. He can upload in our patent website and he can file in electronic mode. So no need to go anywhere, no need to give any kind of documentation. Within your lab you can file a patent. So either in physical mode you can go through by any registry post or speed post, but you have to deposit a DD of the required amount. Nowadays the mode of payment we are also taking either through cash or demand draft or either in electronic mode. So if you want to file a patent through e-filing, then you can go to our website. This is our website. You can click here. You can find out everything. You can find a FAQ there, how to file a patent through e-filing. Everything detail will be presented there. Now come, this is the in 2017 we have developed an app, that is the IPO mobile app. See, until now you have already submitted every document, everything, and now you are in your home. So till now you don't know how is application is proceeding. So we have generated an app. So by just having an app, you can see where is your patent, where is your application stock there, who are the people taking care of your application, what are the problem arises in your patent particular application, whether it has been registered or not, whether the full payment has been paid or not, whether we got an acknowledgement or not. Every detail we will get through this particular app. Now come to document. Till now we know who can file a patent, where we can file a patent, in which mode we can file a patent. Now what are the document need to get a patent of your particular invention? See, basically we need form 1, form 2, form 3, form 5. This 4 form, generally we need this form because these are prerequisite form
to get a patent of your product or of your invention. See, one by one we'll discuss the different form and how it's working. Now come to form 1. See, here the form 1 we have already discussed about the applicant and inventor.